right, John. Today is part 2C of the 3 parts to a perfect estate plan.
That sounds like a joke.
I know it does. It sounds like someone has made this needlessly complex, but we haven't. Everything that we have covered has been critically necessary, and we have already been called out by some listeners for saying, hey, you didn't talk about this.
Right.
If we did, I'm afraid we might have a part 2G. It would still be going, right?
AA.
Yes, right. It'd be like a big Excel spreadsheet.
Right. Well, and the whole point of this entire thing is to give you an overview, right?
Yes.
Because in so many of these things, we have gone into detail. We may have a whole hour-long episode on one little tidbit of something we've talked about. So, I would say if you heard something, you're like, ooh, I wish I knew more about that, or they skipped over this. If you're on, if you're in bigpictureretirement.com, or if you're on your favorite podcast search, if you have a search feature, you can search the topic, and I bet you'll find whole episodes on something like that.
Yep.
So
I know you can if you go to bigpictureretirement.com. There is a search bar there that you can put that information into and pull that up. But I think it's important to make sure we cover this, because we want this to be some pillar content.
That's right.
Listeners can go back to and listen over and over again. So we've talked about, goodness, what have we talked about? We've talked about
planning for incapacity, which was part 1, which had 2 parts.
Yes. Then we moved into talking about what happens after your incapacity is over, meaning that you have passed on from this world.
Right. So part 1 of a good estate plan is having a plan for incapacity. Part 2 of having the perfect estate plan is having a plan for non-probate transfer of assets in the most tax efficient way.
Yes. And then we got hung up in talking about probate, and then we thought we were going to finish it up, but we got hung up in talking about estate taxes, the stepped-up basis, capital gains. So today, we're going to wind up part 2 by talking about some of the common mistakes and oversights, and then just trying to put a wrapper on this second part.
Yep.
All right.
That's it.
So where do we start?
Well, one of the things would be beneficiary designations. Right? We talked about the importance of having a non-probate transfer, right?
Yeah.
And a lot of people know this, right? And particularly their financial advisors or whoever. But for example, we have a large manufacturing plant here in our local town, and you get young guys, 18, 19 years old, right out of high school, that can go work at the big manufacturing plant, make $25 an hour with benefits and everything.
Yeah. Mm-hmm.
Pretty sweet deal, right?
Yeah.
And, maybe they've worked there for 90 days, and so now they can participate in the 401k.
Yep.
And so they go sit down with HR, and HR says, all right, sign up for the 401k. And they sign up for the 401k. And HR, doing what they should be doing, they say, well, you need to name a beneficiary on the account in case something happens to you. And this 19-year-old guy who has married his high school sweetheart, right out of high school, he says, well, I'm just going to name my wife Sally. And so he writes Sally down there. Now, a couple of years down the road, and Sally didn't work out because
Sally wasn't as sweet as she was in high school.
Yeah, just life has moved on, and that young love just didn't have the legs to carry it all the way, and so there was a divorce, and to get a little past that, and this guy now who's in his 30s, he's remarried, he's got him a new wife, and you know what? Turns out that was the one.
He finally found it.
And then 30 years later from there, 40 years later at 75, he's retired.
Mm-hmm.
And he's still got that 401k over at the manufacturing plant, but he's using part of that for his retirement, and he dies.
Yeah.
And you know what he never did?
Never changed that beneficiary designation, did he?
Right. It still says Sally.
Yeah.
His first wife that he hadn't been married to for 40 years. Guess who gets it? Sally.
Fun times
the first wife.
Yes. And this has actually happened.
There's
this isn't just some hypothetical case.
There's a Supreme Court case on what I just described.
Yep.
And the problem there is, like, particularly with a company 401k, right? Your company benefit plans like 401ks, 403bs, those things, they are governed by a law called the Employee Retirement Income Security Act of 1975, better known as ERISA.
Yes.
And that's federal law. And federal law says it goes to the named beneficiary.
Yeah.
Whoever that is. Now, you might live in a state like Texas that says if you've named a spouse as a beneficiary on, say, a life insurance policy and you get divorced, even if you don't change that beneficiary, the spouse doesn't get that life insurance, right? Because they're an ex-spouse now. But that's a state law. ERISA, federal law. Federal law always trumps state law. So it doesn't matter where you live. Doesn't matter what your state rules are. If you name your old ex-wife as the beneficiary on your company 401k and die, she's going to get it.
So that is not the case then. If he would have named Sally as the beneficiary on his IRA.
Probably not.
Aha.
Probably not.
Very interesting.
Because that would be governed under state law.
Yep. And because that is under the Department of Labor's ERISA, then that federal law is what controls that.
That's right. Yeah, but if he had also not changed his company life insurance plan, well, if it's company life insurance plan, governed by ERISA. But if it was, he just went out to State Farm and got him a life insurance policy and never changed it from his ex-wife, well, then she would not get that one. Yeah. Same thing in a will and a trust, right? If I did a will and I left everything to my wife and I later get divorced, but I don't change the will, most states are going to say that wife, prior wife does not receive an inheritance.
Yeah. Now that's very interesting because beneficiaries are one of those things that you don't think about a lot, right? I mean, I know that when I set my accounts up, I set up, my wife as my primary beneficiary, and I think my trust is the contingent beneficiary, right? Or something like that.
Yep.
Okay. But I haven't actually checked that in a while, and I'm a financial planner, right? Now, I'm pretty sure that's the way it's still set up.
Sure.
But, I mean, this is something that people need to check. They actually need to look at.
You need to look at these things.
And make sure.
Yes. And even if you've double checked, so for example, I have, and this is a good reminder to myself, right? So when I moved to Texarkana, I got me a personal checking account at Bank X, right? Where I still bank, except that Bank X got bought out by Bank Y.
Right.
Now, it's the same account number.
Yeah.
It's the same routing number. I still use my old checks even that still say the old bank name, and they seem to work, right? But think about the data transfer.
Right.
When these two companies, one sold out to the other, and merging of all of that data from one system to the next system. Yeah. And maybe where I designated transfer on death beneficiaries at Bank X, maybe that got transferred over to Bank Y. Yeah. Or maybe it didn't.
Right.
But I don't know. I honestly don't know. Now that we think about it, I should probably swing by at some point.
Both leaving with homework.
Yeah, I'm going to have to swing by Bank Y and say, hey, just want to make sure that I've still got TOD on my bank accounts over here. Right?
Interesting. Yeah. So that is certainly something to think about with beneficiary designations. But, one of the things that we've talked about before, I think we had an episode where we talked about the fine print of beneficiary designations. And so even if you check your beneficiaries and you go, okay, I've got my 2 kids on here, my wife is first, then my 2 kids are after that. That's still not really enough, is it?
It maybe not, because so this whole part, one of the parts of this section of our 3 parts is having a strategy for non-probate transfer, right? One way of accomplishing that is beneficiary designations.
Right.
The downside to beneficiary designations is the lack of contingency. So you say, okay, I'm going to leave everything to my 3 children. Yeah. And so you name the 3 children and you go and confirm that.
Right.
What happens if one of those children predeceases you?
Yeah.
Because that is going to be governed most likely by the contract.
Yeah.
Whether that's the bank or whether that's the IRA custodian or whatever it is, they're probably going to have a rule. What happens then in that circumstance? And you may not know. And when you find out the answer, you may not like it.
Right.
Because, for example, if I were to ask you, and I said, okay, you've got 3 kids, each one has their own children, right? So you got the mess of grandkids out there as well. So child 1 predeceases you. Would you want what was going to child 1 to go to the children of child 1?
Right.
The answer would probably be yes. Yeah, they get their share. Perfectly reasonable. That's the natural disposition. Not necessarily the standard in a contract.
Absolutely. Yeah.
And I know you've had this
we have
with a client.
Yeah, no, this almost exact case.
Yeah.
Yeah, that was a and because you never really know. We were talking about planning for incapacity, right?
Right.
Well, in this case, the client and his child were incapacitated, and then the child died, and just a week or so later, the client died. Well, he had 2 kids, and one of those was now dead.
Right.
His estate was supposed to be split, and these accounts that he had were supposed to be split between these 2 children.
Right.
And thankfully, because we had made the right elections on that beneficiary designation, it went to the deceased child's children, and then the other 50% went to the child that was still alive.
Right.
But many entities out there, many of these financial institutions have a default that they will elect for a beneficiary designation, and sometimes it doesn't go just like that.
Right. A lot of times it goes to whoever is living.
Yes.
It goes to the living beneficiaries.
Yep.
And if you think about it, if you ran a bank or you ran a financial institution, this makes a lot of sense, right? Because you build into your account agreement what's going to be best for you, the bank.
Yep.
And for you, it's, hey, if you name 3 people and one of them's dead, we're just going to pay it to the other 2, because that's easily identifiable.
Yeah.
If you say, well, we're going to pay it to the children of the deceased, well, who are they?
Yeah.
You don't know.
Right.
You're the bank, so you don't know who to pay it to, and you've opened up a whole issue there. So you need to, but if you're the client, if you're the customer, that's probably what you want. And so you need to double check and make sure all of those things.
For sure. So what is it? There's different names for this, right? You've got pro rata and per stirpes is what I've always referred to it as.
That's right.
But I've heard it called different things as well.
You may hear per capita.
Yep, per capita.
Per capita with representation.
Yep.
That's one, which is what most people actually refer to as per stirpes. But yeah, so the idea is like a per stirpes distribution would be to the descendants of the deceased person.
Right.
Pro rata would generally be among the living.
Right. Yeah. So, for example, in my case, with my 3 kids, if one of my children predeceased me, then it would just, his share and his estate's share would terminate.
Right. And it just goes to the other 2. Yeah, it just goes to the other 2.
The per stirpes, I think it's Latin for by the branch or something like that.
Something like that.
It would go to his children, which, by the way, John, I don't know if I've told you yet, I have a grandbaby on the way. Have I told you
You
that?
did. I was last time we were over here recording, there was a ultrasound.
Yes, that's right. That's right. Coming in August. Her name will be Ellis Ann.
Ellis Ann. Very
Can't
nice.
wait. It's going to be fun.
Yep. Well, I've got number 2 grandchild on the way.
That's right. You do. Number 2.
Come November. So there you
And unfortunately, they don't live here in Texarkana.
Nope, they live far away. Yours are close, so
Yeah.
you'll get stuck babysitting and changing diapers very shortly.
I don't know about that. That sounds like a grandmother job to me. So we've got beneficiary designations, making sure that those are right, reviewing those, doing this fairly frequently. And I'll tell you, John, here at our firm, we've actually added this to our checklist.
Oh, yeah.
So we have we call it our annual alignment meeting, right? Where we're going through and we're looking at the next 12 months ahead. One of the things that we always want to make sure of is that these beneficiary designations are still who you want them to be.
Right.
Because sometimes people you'll hear somebody griping about their kids or whatever, and for whatever reason, they thought that you took that to mean that you would change their beneficiary designations or for whatever reason, right? So we just always want to go through and we want to make sure that everything is set up right. And as you're reviewing those, you also need to make sure that, if it's at an insurance company, if it's at wherever it is, that it is set up by either pro rata or per stirpes. And many of those will let you notate that on the beneficiary designation, where you can actually write it in if you have to. And with some of them, they'll have a checkbox, but with some of them, you have to write it in. Now, we haven't tested that yet, but they've told us that, yes, this will work. I don't think that we've ever had like an insurance company where you had to write that in, because some of these insurance companies are really small.
Yes.
I mean, some of them literally have less in assets under management than my firm, right? And they're out there doing these annuities. And I've never really tested what happens if you write that in and then you have to process something out. Do they actually go by that? But they're supposed to. That would actually show what your intent was, nothing else.
And this also goes to the point of when you're doing something like planning with a trust as your primary vehicle, you can avoid a lot of this by just naming the trust.
Yeah. Yep.
Because the trust, at least if it's well drafted, is going to have all of these contingencies covered already.
Absolutely.
And the trust doesn't die, right? So you just name the trust and go away.
Yes. Yep. And that makes sense. And just to cover that real quickly then, with the Post-Secure Act trusts that are out there, you can name those as a direct beneficiary of your IRA. Most of them, right? They should have the qualified language in that will allow you to do that.
I wouldn't go so far as to say most of them. I would say that they should.
They should.
They should.
Yeah, they should.
But if you did a trust prior to what, 2021, 2022?
I have lost track of all of the changes that have come through and when they came through.
If you did one,
I was thinking that one was 2019.
Okay.
And it may have been the one after that.
In any case, if you did your revocable trust prior to, say, the last 5 or 6 years, so if you did it 10 years ago, it's not up to date.
Yeah.
You need to go get it looked at.
Yep.
Particularly if you are naming that trust as a beneficiary of IRAs.
Yes. And even if it's on a contingent basis, right? It's going to accelerate the timeline that has to be paid
It could
out.
have very negative tax consequences.
Could be very negative. Accelerate it to a 5-year.
5-year payout.
Yeah.
That's right. All right. So yeah, so common mistakes. So failing to update your beneficiary designations. Speaking of trusts, I would like to think that this is obvious, but failure to fund the trust.
Mm-hmm.
So you know what I just bought? I got on Amazon. You know what I bought? Little buckets.
Oh yeah.
Little like aluminum buckets. A little bit yay big.
Yeah.
And you know what else I bought? I bought dollhouse items.
That's getting creepy.
A little house, some little fake money, and a little car, and right? Like I bought little things.
Yeah.
And when I'm sitting there with a client and I'm explaining to them, look, the trust is just a stack of paper until you put your assets in the trust. That means you have to retitle your house into the name of the trust. You have to go to the bank and retitle your bank accounts and savings accounts and CDs into the name of the trust.
Yep.
You have to go to your financial advisor and name the trust as the beneficiary on.
Right.
So you have to do the work. You have to fund the trust. Otherwise, so many people will go and they have a trust drawn up and then they don't do anything.
Mm-hmm.
In fact, I've even seen where law firms, they do the trust for them and they don't even put the real estate in there.
Yeah.
And the client thinks that once they've done this trust, they're done.
Yeah.
And they're not. That's just the start, right?
And can we admit that from the consumer side, right, the one having the trust done, it's a pain in the butt.
It is.
To have to do a lot of it. For example, at my bank, I still haven't put my personal bank accounts in the name of my trust. You know why? Because all of my online payees are linked to my personal account.
Correct.
And I can't just retitle that account. I've got to open up a whole new account.
Right.
No, thank you.
Although you could name the trust as the transfer on death on that personal account.
Which I have.
Which you did.
Yes.
So, but again, but you're right. This is a process, right?
Yeah.
But if you think about it, the transferring of assets, it's going to happen.
Mm-hmm.
It's either going to happen now, or it's going to happen at your death. And if it's happening at your death as a part of a court process and all the other things that we've already talked about, that's what you were trying to avoid by using the trust. So you got to get the things in the trust. So, and I've explained this to clients, and I'm sitting across the table from them, and I'm getting that blank stare.
Yeah.
They're not picking up what I'm putting down.
Yeah.
And so just this week, I reach over and I grab my little tin bucket, and I said, "This is your trust. This bucket here, and see this little house. I'm going to put your house in the bucket. I've already done that, but." Here's some things you need to put in the bucket. And I slid the little money thing over there. I said, this is your money. Yeah. It's at the bank. I need you to go and put it in the bucket.
Yeah.
They finally wrapped their mind around
we see it all the time. People come in here with trusts that are 2 or 3 years old. Do I need to do something with this?
Yes.
Yes, you do.
Yes. Right. So failure to fund the trust.
Which inside, usually in that first pocket, will be a set of instructions.
Typically. I do it.
That say, hey, you need to get in touch with your advisor.
I love how you keep saying usually when your only experience is
pretty much.
Your only experience is me, and to pat myself on the back, I do it correctly.
That's right. We do have quite a few virtual clients. Almost all of our clients now are virtual, and some of them do have other attorneys they use. John, I hate to tell you that, but we have had to work with some other attorneys. And no, I don't like most of them as much as I do you.
Well, that's good. Yeah. That's good. But they said that in any case, we're talking about some common mistakes. And so, not getting your beneficiary designations right and not funding your trust. Couple of big ones.
Yes.
So what do they need to be doing out there? You first of all, to summarize this entire segment, right? Are you, as you sit here right now, if you think you have done your estate planning, right? If you think you have done your estate planning, can you say for relative certainty that if you died right now, you just fell over dead, that there would not be a need to probate a will at your death?
Right.
If you're not mostly certain about that, you need to be having some advice, right?
Right.
So first thing first, right? Because again, that's the whole point. Avoid the necessity of probate, have a non-transfer of assets in some way, shape, or form. And you need to be asking yourself, have I set everything up with that goal in mind?
Well, let me just stop and get some personal advice from you. Since we're recording, you won't send me an invoice.
All right.
So as you know, you and I are both fans of Toyotas.
Yes.
And I especially am a fan of the FJ Cruiser. I think it's a fantastic vehicle. They're built like a tank. Very, very few electronics in those. So I've got 2 FJ Cruisers now, and one of them is worth a decent amount of money. So we're in Texas.
Yep.
This particular vehicle is registered in Texas.
Yep.
The title is in, I don't know, I guess my name. Probably. Maybe myself and my wife.
Maybe
I'm not sure.
Maybe you and Karen.
Yep. Who knows? That's going to have to be probated, right?
It could be, but we were just talking about naming beneficiaries, right?
Yeah.
Texas Form VTR-121.
So does Texas have a transfer on death title now?
It does.
Well, since when?
It's been a couple of years.
Really?
Yep.
And we've recorded these episodes, we've had these conversations, and yet you haven't felt the need to tell me that.
Well, now I'm telling you now.
You are now.
I'm telling you now.
So.
And many other states have this as well. We had a listener question, and one of her comments in there was they have beneficiary designations on everything, including their vehicles.
See, I did not know that Texas had that. I knew there were other states because we've had this conversation in the past.
Yes.
About this on your house, how you could have a transfer on death on your house.
That's right.
And I knew that there were some states that did it on cars, but now that I know that Texas does.
Yep, and Texas does.
I need to get my FJ Cruiser and my Honda Pilot and my 2008 Toyota Tundra.
I will send you a link
Yes.
Right here from the laptop.
Do that while we're recording the episode.
While we're
Let's
recording
take care
the
of some
episode.
personal business. So I'm trying to think of anything else that, because I know I'm going to put myself in the shoes of the listener here. And I'm sitting here thinking, all right, my house is taken care of. It's titled in the name of my trust. My accounts all have beneficiary designations on them. I'm going to do this transfer on death on my cars.
And then and then the last thing is because we talked about the taxes. So are you going to, based on you and the size of your estate, are you minimizing or eliminating the death tax? Are you maximizing the step up in basis? And are you minimizing any income tax on your beneficiaries from your IRAs and annuities? And the answer should be yes to all of those things.
Yeah. But what else could I have in my house, in my possession, in my assets that might have to be probated? I'm still working through that. What about art?
What I generally tell people is I say, look, if we've done, whether it's trust or whether you're just naming beneficiaries, right? But we'll just say beneficiaries. So you've named beneficiary on your house, on your car, on your bank accounts, on your IRA, on your 401k, on your CDs. So what's left? What's left is your stuff.
Mm-hmm. Right.
It's your couch.
Yeah.
It's your plates, and you don't have to probate a will for your junk. Your kids don't want it anyway.
Hey, I'm not so sure about that. I don't know if you remember this, but you and I went to Dallas, Texas in 2017.
Yes, this is where you introduced me to the taco place.
Oh, Velvet Tacos.
Velvet
Ladies
Taco.
and gentlemen, if you're ever in the Dallas-Fort Worth area, you got to try Velvet Tacos.
Yeah, you introduced me to the Velvet Taco.
And it's been an obsession ever since.
And it has. It's quite good, yes.
While we were there, just down from Velvet Tacos on whatever road, Henderson, I think that road is called, there was a store there. And I went and I bought this bronze from, I've forgotten the name of the artist now, but I'd had my eyes on it for a while. And, so something like that. I mean, if you've got a piece of art that's worth several $1,000s.
Now, here's one thing I will say, and you already know the answer to this because it's in all of your existing estate planning.
Yes, sure I do.
But one of the things, there's actually two parts to this. So one, in your revocable trust, there's a statement on probably page 1 or page 2. And it says something to the effect of, by creating this trust, we are transferring all of our assets to this trust.
Excellent.
Even if we don't physically change the name or ownership.
That's right. And what do you call that provision? There's a name for it.
So we call it a magic wand provision.
Oh, okay. It seems like that's what I've heard you call it before.
And the idea is that's to give some indication that something like this bronze statue is part of the trust.
Yeah.
Right. To back that up, though, we also do an assignment of personal property.
Okay.
And this is just a 1-page sheet, and it says, I hereby assign all right, title, and interest to all of my tangible personal property now
Excellent.
and acquired in the future to the Carroll Family Trust.
So now the couch
Is part of the trust.
would be owned by the Carroll Family Trust.
That's it.
Well, that was a simple answer.
It was.
Yeah. And when you said earlier, no one would want this stuff, you could have just said, hey, it's taken care of.
They
You
still
don't have to worry about it. No, they don't. You're probably right. Most of it, they don't. So that's interesting because I get those questions quite a bit from people that's like, hey, Devin, look, I've done all of this, but I've got this boat. And sometimes boats, depending on the area of the country people are in, they could be worth a lot of money.
Yes, they can.
A lot of money. And, they're like, well, I'm assuming that in some states, if you can do a car, if you can do a house,
You can probably do a boat.
you could probably do a boat as well.
Absolutely.
Yeah, perfect. All right. So we talked about non-probate transfers. We talked about how to make sure your beneficiary designations are right.
Right. And kind of these best practices and some things to look out for.
And when we come back to do part 3,
Yep. We're going to start on part 3 next.
we're going to talk about protecting the beneficiary's inheritance.
Right. So part 1, plan for incapacity. Part 2, plan for non-probate transfer at death in a tax-efficient way. Part 3, protect your beneficiaries.
Yes. Excellent.
Plan for what you hope doesn't happen. And we'll talk more about that.
That's going to be good stuff.
In episode 3.
So let me read you a review that came in.
All right.
I can't remember where we left off reading these reviews, so I hope I haven't forgotten a good one because I'm looking at a string of 5-star reviews.
That's
here.
As you would expect.
Well, all I can do is just start at the most recent. This one, the title of it is Straight Shooters. I'm a longtime listener of Devin and have always enjoyed his unbiased commentary on Social Security issues. I'm not sure I like this. But then he says, adding John Ross has made this a must listen for me.
Yeah, it was a meh before that.
Once I added you, though,
but
must listen now.
Now it's a must listen. Before, totally optional. When it was just Devin, totally optional. Now it's a must listen.
Well, to the person who left that, who went under the name of Bladboy, we appreciate the review.
Absolutely,
and to all of our other listeners, we love seeing these 5-star reviews, and they absolutely do help in spreading the word to the other audience people. All right. Well, that's it for today's episode. Thank you so much for listening.